Okay, we've seen how Judge Hippler has ruled when it comes to some of the defendant's motions. Let's go ahead and see how he's ruled on the states. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we've got a 17-page document that has several different motions being ruled on when it comes to Judge Hippler's decisions, and it's called the Order Memorializing the Oral Rulings in Motions in Limine. This video right here, we went over all of the rulings for the defendant's motions. This video, we're going to do all of the state's motions, and then we're going to be doing the separate filings that we have left in separate videos until we get all of the rulings reviewed. Now, again, if you've missed the defendant's portion of this, the video looks like this, and a link for it will be down in the description box. As you can see, I had the defense ones highlighted in yellow. Those are in the first video. We skipped over all of the green ones, and now we're going back, circling back, and finishing this document in part number 2. Now, this first one that we are going to be going over is the state's motion in limine regarding improper death penalty comments. The state moves under IRE 401 and 403 to preclude defense counsel from making what it calls improper comments about the death penalty, specifically that the state is attempting to kill the defendant, which defendant counsel has stated in past hearings. Defendant stipulates to using phrases that comport with existing language in statute and jury instruction. Again, the court is unwilling to enter an order requiring defense counsel to act professionally and comply with existing rules. As defense counsel recognizes, such statements would be argumentative and improper. The court trusts defense counsel will comport themselves accordingly. The motion is denied as unnecessary. It was unnecessary. No prosecutorial misconduct, because you have to be reminded to follow the rules, apparently, as these lawyers seem to always have to be. Going all the way down to page 5, the next one is the state's motion in limine regarding alternative perpetrator evidence. They don't want the defense to just come in and start saying, there's all these different possibilities for what could have been. They need direct evidence. This is something, again, that we heard them talking about in the motion hearing. And what the judge basically said was, you need to show me proof. It can't be just, again, all these different possibilities and circumstantial really nothingness. There needs to be some substance to it, which, practice what you preach. But basically, he wanted this evidence submitted prior to the pretrial conference hearing that I believe is on May 15th. I don't know exactly the deadline date he's going to give them to turn this stuff in prior to that, because he's going to need time to go over it and see if it's substantial enough. But if it's substantial enough, what is he going to do then? Does that mean that he gets to be like, okay, I'm going to go ahead and sign off on these search warrants to get more of this information coming in because this investigative theory really has some legs here? Like, if it's something that can actually be admitted at trial as alternative perpetrator evidence, why can't the cops move on it for a possible arrest? I need somebody to explain that to me. It says, the state seeks an order prohibiting defendant from offering alternate perpetrator evidence without first making a showing that such evidence is relevant and admissible under IRE 401 and 403. These rules govern the standard of admissibility for alternate perpetrator evidence. And it cites State versus Meister from 2009. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403. Defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to defendant, this case is full of alternate perpetrators, and he intends to produce offers of proof as to alternate perpetrators. But see, that's the thing. I don't want to hear full of alternate perpetrators. That's why it's hard for me to come out and give my direct theory. Besides, I have a lot of suspicion behind the fraternity and whatever all the secrecy is regarding Ethan and Xana, and the way that the university, Scott Green, the way that they came in and took over and had the house gifted to them and had it completely demolished and destroyed. And all of it is just so much crazy, insane, circumstantial suspicion. But I can't really come out here and point fingers at names because I don't know. I just know how I feel about certain things. I can't take what I feel about certain things and bring it into a court of law and expect a judge to make a ruling on things. I can give you examples of why I'm suspicious and make it sound good to get like search warrants and other things like that under circumstantial evidence type things. But when it comes to this, they have to have more than just possible. They have to have some proof. And if they really do have these two like full-fledged investigators working the case, I want to believe that they have something with some backing. I hope I don't end up disappointed. I really hope I don't. It goes on to say that while defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. Laying foundation for the admission of the evidence will likely take a significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. They are quoting out of this Jones on Evidence 7th edition that had an update in December of 2024. To avoid undue delay at trial, defendant must present the offer or offers of proof no later than May 14th of 2025, so the matter can be addressed at the pretrial conference, which again is May the 15th, and there is a footnote number 5. The scope of the preclusive effect of this ruling includes suggesting that specific individuals looked at and cleared by law enforcement are alternate perpetrators without first complying with a showing required by this order. Okay, but what if it's somebody that wasn't looked at and cleared by law enforcement? Because that's possible too. There could very easily be somebody involved in this shit that the cops didn't even look at on the real. So it's kind of odd that this like very specific verbiage is in here too. So I guess it just depends on the kind of evidence that gets submitted by the defense. But for it to be being turned in literally the day before the pretrial conference, it doesn't seem like the judge is going to have a lot of time to really go over much. Unless it's the only thing that he has to go over at the time. We'll see. The next one is on page 8, and it is the state's motion in limine regarding the AT&T timing advance records, you know, where Judge Hippler came out and called Cy a conspiracy theorist, basically. The state moves in limine to prohibit the defense from making any reference to the absence of AT&T timing advance records related to defendant's cell phone. The state contends it never received such records from AT&T in response to its subpoenas, and therefore, any statements by defendant that the records could have or should have been provided to defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. In support, the state provides certificates of authenticity, AT&T, for each of the 2 warrants, stating that it did not provide timing advance records for phone number 509-592-8458 because such records were at the time only available if requested within 7 days of the specified time frame. And there is a 9th footnote that states, the homicides occurred on November 13th, 2022. Defendant first became a person of interest on December 19th, 2022. Defendant first became a person of interest on December 19th, 2022. The 2 AT&T warrants were issued on December 23rd, 2022. Thus, timely advance records for defendant that could have been of any relevance had long been discarded by AT&T and no longer exist. Now, this is the judge stating that the defendant first became a person of interest on December 19th of 2022. So if for any reason they're going to try to backtrack that and try to say that they knew who he was before December 19th, I don't know how they're going to just dance around that, considering the feds had the family tree information around the 10th of December. We know damn well that they had something to do with the traffic stops in Indiana on the 15th of December. We now have proof that there was something that happened where Bryan Kohberger was observed walking in and out of a CVS on the 16th of December, and somehow law enforcement of some sort were able to go in and like get information about him being in that CVS and CVS related information regarding Bryan Kohberger. But we also know that it wasn't for 4 or 5 days after that the Pennsylvania agencies were even informed that there was something happening. So the feds were heavily involved in this situation way before any local law enforcement agencies knew who Bryan was. And again, they're trying to lie. They're trying to lie to the jury about how they actually got to the defendant. They're just expecting us all just to watch and not say a word about the blatant lies. It's just so gross. Now, I did show you guys a letter that I found that was actually dated, I believe it was August of 2022, so it was before the crimes even occurred, where a high up at AT&T was answering the White House, our government, about how they stored location data for their customers. And they basically retain it for 5 years, is what this letter claims. And this is, again, before the crimes. And they're mentioning the GLDC company that AT&T does all this stuff with, that they work with in order to obtain all of this location information and keep it and store it. So I don't know where all this whole, it has to be requested within 7-day thing is coming from, besides what we're hearing from this case, because I'm not seeing that when it comes to the stuff available online from people that work at AT&T regarding the way that this works. We're only hearing that from these certificates of authenticity, which is interesting. It goes on to say, defendant relying largely on the affidavits of its expert, Cy Ray. That's not the only expert regarding this that they have, though. They have another one besides Cy Ray. So 2 altogether and 2 investigators. And now, of course, they have their DNA expert, now also an actual trial attorney. So they're trying to bring in all the actual experts here so that real knowledge and science can actually speak for itself, which is way more than what the state's honestly trying to do from how it seems. Defendant is adamant that the state did receive the documents, which he argues are exculpatory, and is hiding them. Defendant points out he has a constitutional right to challenge evidence against him and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. And remember, the very first thing that we were ever told regarding Bryan Kohberger and anything that he had to say after his arrest was that his phone data was going to be exculpatory for him and that he could not wait to get to Idaho in order for basically his phone information to exonerate him. That's been theme the entire time. The 6th and 14th Amendments guarantee a criminal defendant a meaningful opportunity to present a complete defense. This includes the right to confront and effectively cross-examine witnesses, and it cites Davis versus Alaska from 1974. However, these rights are not absolute, and now we have State versus Areza from 1993. The trial court may reasonably limit cross-examination that is harassing, confusing, repetitive, or only marginally relevant, and it now cites Delaware versus Van Arsdale from 1986. The Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. Now they're quoting Delaware versus Finsterer. in 1985. Additionally, a defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. And this is State versus Self from Idaho in 2003. Applying these principles here, defendant will be allowed to voir dire special agent Balance outside the presence of the jury to ask whether he received defendant's TA records covering the early morning hours of November 13th, 2022, and the months prior when defendant was believed to have been in the area of 1122 King Road. However, if agent Balance denies having received the TA records, defendant may not explore the matter further, either in voir dire or before the jury, given the absolute lack of any factual basis supporting his position that the state is hiding them. So even if it is true and Balance lies about it to save his own ass, the defense is not allowed to keep hounding them about it because they think that they're lying. Okay, so now we have footnote number 10. Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded and thus highly improper accusations against the state. Further, not once in his affidavit does he address AT&T's 7-day retention period, which fully explains why the state was unable to obtain relevant TA records for the defendant. I get it, if that's the truth. Again, I showed you guys a letter. I will have it in the description box. I'll even have it popped up right here as I'm talking. It literally says they hold location data for 5 years. So I don't understand what the issue is here, what they're actually acting like they don't have, while also trying to say that they have enough location information to actually put him there and prove that it was him. But if you don't have these records, how do you have what you need to then prove your case? Again, this is one of those things to where if you have it and it's exculpatory and you're hiding it, then you're in trouble. But now you're telling us that you have something that gives you location information for him, but it's not these AT&T timing advance records. It's something else completely different. See, that's why I'm not, like, I don't do tech stuff. This don't make no sense to me. If you got information, location information, and tell us that he turned here and did this here and did this here, but you don't have this type of location information, then I don't understand. This is just one of those things I'm not afraid to say I don't understand. It sounds like you have location information. So why are we being told they don't have location information if they keep saying they do have location information? See, that's why it's confusing to me. It should be confusing to everyone, honestly. It ends with, thus, the state's motion is granted, except as qualified regarding the very brief voir dire outside the presence of the jury. Meaning, sure, you get your way, except for if the defense wants to talk to Balance and he can lie to them and they can't do crap about it afterwards. So if they want to do that, let them do that and get it over with, and then let's get back to this narrative that I told y'all to create. This is wild. The next one is regarding the self-authentication of records in reliance with the IRE 80368 and 902411 and IRE 80324. That is that self-authenticating records list that we went over, and then they came in and removed a bunch of stuff from it. That's also the list where we found out that they don't actually have any DoorDash account information submitted for Xana. The DoorDash was actually ordered from Ethan's account, and everything about it having something to do with Xana doesn't make any sense anymore because everything being submitted is about Ethan's account. And there's like no proof about anything when it comes to Xana. So just in case you guys didn't know what that was, that's the list where we found that information from. And the state went in and removed a whole bunch of financial records that they are no longer going to be submitting. The Winco information where they had like surveillance for, I think it was Bryan, or maybe it was like transaction information from Bryan, and then surveillance stuff for like all of the girls in the house. And then they ended up taking that away. It was like the one thing that they actually had where it was the same company for both the suspect and the victims, and then they removed it because there was nothing there. I mean, I don't know what they're going to submit that's going to actually prove anything. I really just don't. They've submitted everything. The judge has seen everything. The defense at this point has seen everything. Their story is weak. It's going to be interesting to watch. I know that. The state's motion in limine to permit the admission of approximately 60 exhibits pursuant to IRE 8036 and 8 and 24. See, I don't believe it's 60 though, because we went through the entire list and they removed so many of them. We went through the retractions too. I'll have links for those videos down in the description box as well. The state represents that it will obtain and submit certifications for the foregoing exhibits to render them self-authenticating under IRE 9024 and 11. However, as the state acknowledges, IRE 90211 contains a notice requirement that has not been satisfied. To this end, the court will require that, after proper notice is given under IRE 90211, the parties are to meet and confer regarding self-authentication and any objections defendant may have to specific exhibits prior to raising the issue with the court. The court's ruling on the motion is reserved. So once again, the court doesn't want to make a ruling. They want the two sides. Well, it's not even they. It's the freaking judge. It's Judge Hippler. He's not choosing to be a judge and make a ruling, to make the call. He wants the two sides to work together to figure it out. What's the point in this guy? The next one is regarding the demonstrative evidence, which is really just a completely not to scale bullshit dollhouse that at the time that we heard about it at the hearing wasn't even completed yet. Like, the defense just got the Pharaoh scanning stuff, like, I think right after the January hearings, sometime in February. That could be wrong. Don't hold me to that. I'm going off of my brain, and there's lots of dates and information moving around in there. But they just recently got, like, the Pharaoh imaging. And the two times that the Pharaoh scanning was done and all that money that was spent, and they're getting a not to scale dollhouse that's being made by some Fed and not a dollhouse maker that actually could make it authentic. It's just insane. Okay. The state seeks permission to use a not to scale 3D model of the 1122 King Road residence as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish the basic accuracy of the model and a demonstration that it will be helpful to explaining the testimony of the presenting witnesses. The state contends the model will aid certain witnesses in describing their testimony. Defendant objects, arguing the state's drawing of the model and other related information was only recently disclosed in discovery in a file defendant described as massive. And we have an 11th footnote that says the other information was the identity and credentials of the person building the model and the data underlying the model. Not just did they just get this stuff, but we also need to remember that Ann Taylor said at this last hearing there was more discovery that she had to go pick up after. So they're still getting more and more stuff sent over to them with trial coming up. Like, I'm telling you, there's probably going to be somebody asking for an extension because of all this new stuff all of a sudden coming in, just like magically being pulled out of people's butts and being handed over after almost 3 years. It's just wild that's even being allowed at this point. Defendant claims the data and model cannot reasonably be evaluated by its expert in time. And there's a 12th footnote. Defendant submits the declaration of its expert, Matthew Kernodle, wherein he discusses these clerks of court do better. I mean, I could use another side job. I'll do it for you. This is ridiculous. Wherein he discusses that it will take at least 3 days to assess the 3D scans recently disclosed by the state, and he will thereafter have to set aside at least 2 days to travel from Seattle to view the model to assess its accuracy. He states he is unavailable until at least April 7th, 2025. However, defendant has ample time prior to trial to accomplish these tasks. Okay, April 7th, 2025. When the frick did you sign this? This was filed on my birthday, on April 18th. When was it signed? April 17th, the day before. Why are we putting a footnote that has past tense information? That just makes things confusing. Defendant disputes that the model is relevant, and even if it was, claims it should be excluded under IRE 403 due to the danger it might not be accurate. They should have never gotten rid of it. Acoustics matter. The way that house was put together and where the girls were, especially with Dylan's bullshit, especially now that we're hearing there's a possibility she actually saw Xana at the time of the event, and even at the time of seeing her at the time of the event, thought she was just passed out drunk. hearing the way that the 911 call was presented and the way that they were adamant about, oh, she just drank too much and she's passed out. We need that house to still be there. It's so disgusting that they made this choice and that no one of authority felt the need to step in. It's just wild. The trial court has discretion in allowing the admission of demonstrative evidence. Here, the court finds the demonstrative exhibit is relevant, assuming foundation can be laid, because it will supplement the testimony of witnesses or assist the jury in obtaining a better understanding of facts in issue. The homicides occurred in 2 bedrooms within a 3-story home with a complicated layout. Exactly. That's why it should have been left alone. The suspect's ability to enter the home, carrying out the stabbings, and exit the home consistent with DM's observations will be a central point of the trial, particularly given that defendant is challenging whether it could be accomplished by one person within the time frame alleged. So they're still claiming that everything from this completely unreliable witness is going to be the main central point of the entire trial. We just heard it. And remember, the defense did come out and state that their experts are claiming more than one weapon, more than one person, and they have the proof. The model will aid the testimony of lay witnesses and experts alike in explaining the location of victims, witnesses, and other items of evidence, as well as understanding the suspect's potential or likely path of travel. Moreover, though it is not to scale, accuracy is not the standard governing relevant of illustrative evidence. Rather, the illustrative evidence must only be relevant to the witness's testimony. Accuracy is not the standard? I'm sorry? Is that what we're going to live by? That's the motto we're going to live by. Accuracy is not the standard. So long as the exhibit is not deceptive, it does not have to be shown to be precisely accurate or consistent with the testimony of other witnesses. Then it cites State versus Rodabaugh from 1993. Diagram properly admitted where not to scale and admittedly inconsistent with another witness's testimony. So there was already an issue with an inconsistent situation in another case. Okay, let's see what 13 says. See also State versus Ehrlich from 2015, forensic artist model of crime victim's head, properly admitted despite discrepancies in size. Discrepancies were small and jury was aware of them. And then State versus Hall from 2018, images illustrating experts' opinion about how victim was tied after death admissible, even if they do not exactly depict the event. Why are things that are not accurate to prove the facts that actually happen being constantly admitted into cases? Holy shit. While defendant's expert, Mr. Kernodle, contends there is a risk that State's model could be misleading if it misrepresents the location of a wall or a door or an actual line of sight, those are simply concerns at this point. I'm sorry, you literally have in your probable cause order for arrest that Dylan witnessed this person going in a certain direction, and therefore your detectives who were getting this warrant signed in order for the arrest of Bryan Kohberger said that based on their experience of what Dylan was claiming that she saw, that meant the person might have gone out the back door. Considering the fact that so many people have already determined that there's no way that Dylan could have been able to see if the person exited or went somewhere else in the house or not, how is this simply a concern at this point? The facts are the facts. And if Dylan's story does not add up to what she's claiming to have seen, where she's claiming to have seen it, and how all of the actual walls and turns and curves and corners actually work, that's a problem. That means she's making shit up. And this guy, once again, doesn't care. Just like he said to us, that it doesn't matter that all these things that the feds did happened, they're constitutionally unimportant. They happened, they just don't matter. This is where we are. This is insane. The state intends to lay foundation to establish that the 3D model fairly depicts the residence, and if it fails to do so, the model will not be allowed. Further, defendant is free to cross-examine the testifying witness and to put on his own evidence, including experts. He may also use his own demonstrative exhibits if proper foundation is laid. So does that mean they can take those Pharaoh scans and all the measurements and go get their own dollhouse made? Let's do it. Dollhouse to dollhouse. However, the state is not going to be held to a standard of precise accuracy in this regard. It will only need to demonstrate accuracy to the point of avoiding deception. In addition, there is no basis under IRE 403 to exclude the model. Defendant contends that allowing the model is prejudicial because it is built from data that was untimely disclosed and which its experts has little time to analyze for accuracy. Number 14. Defendant also argues it is prejudicial to the extent it is not accurate, but the court rejects that argument for the same reason it rejects defendant's relevancy argument. Yeah, because, doing things correctly apparently is just not favorable to the court. While this might be a more compelling issue if the state was seeking to introduce the model as substantive evidence or seeking to have the model accompany the jury during deliberations, it is not. It is simply going to be used as an educational device meant to aid in the presentation of evidence that will not go back with the jury during deliberations. So they can't take the house with them to discuss what they've heard, the way that they're being told that she saw things or anything else. I don't really know if I like that very much. I mean, I know that it's not to scale, but in order for them to deliberate the facts correctly, I think they probably should have whatever is used to tell the story with them in order for them to get it accurate. But again, all those tools need to be accurate as well. This gets on my nerves. Moreover, as discussed, Mr. Nodle's concerns about his time constraints are based on his impression that he will have to analyze the underlying data to ensure the model's proper scale, dimension, and completeness. Again, accuracy is not the standard. Mr. Nodle need only assure himself the model is not deceptive, and there is sufficient time to do this given the August trial date, and now we have number 15. Assuming the state can lay sufficient foundation for the model, the court will entertain a request to provide a limiting instruction to the jury that the model is not intended to be accurate and is not to be considered evidence. I just don't understand how you can say, hey, this is part of what the story is, but it's not accurate. It's not actually correct. I just find it so ridiculous. To this end, the state is to make the model available to defendant as soon as it is completed and no later than the pretrial conference. This motion is granted. And I believe we were told that at the time of the motion hearing that it only needed 10 more days, so it technically should have been already done by now. Now we have the state's motion in limine regarding Bryan Kohberger's alibi. The state moves to preclude defendant from offering any evidence in support of an alibi other than from defendant himself. I am bothered by this because Bryan Kohberger's phone information is him presenting his own alibi defense. And that's the biggest argument besides the IGG in this entire thing. Yeah. The basis for the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence. And again, he's claiming he was out driving alone by himself. Millions of people a day can say that. They are driving around by themselves. Most of them turn off their phones and turn on their music on the radio and just zone out and drive. As ridiculous as that probably sounds to some people, that's very common for a majority of humans. Pursuant to IC 195191 and ICR 12.1, if requested by the state during discovery, a defendant intending to offer an alibi must file a notice listing the specific place or places at which the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Well, we were told a direction and a park that he went to, so I think that pretty much complies. Just because he doesn't have a human being to offer over doesn't mean it's not an alibi. The court has the discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from the scene of the offense. An alibi is a defense based on the physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. Black's Law Dictionary, the 2024 12th edition. Hence, in setting forth the notice requirements for an alibi defense, IC 19519 and ICR 12.1 require a defendant to proffer evidence establishing where the defendant was at the time of the alleged offense. Evidence only counts as alibi evidence if it proves that the defendant could not have been present at the scene of the offense at the time that it was committed. That's what they're trying to tell you. With the location information that y'all are claiming y'all don't have, but do have at the exact same time, the confusing shit. If any alibi fails to account for a defendant's whereabouts for at least some period of time during which the crime was reasonably committed, it is not an alibi. And they cite a few different cases. Williams versus State from 2016, a partial alibi is no alibi at all. And then U.S. versus White from 2006, the defendant was not entitled to an alibi instruction when his witnesses did not account for his whereabouts at the time of the offense. Now, we don't have anybody claiming that they're being used as an alibi and it's a lie or anything like that before that crazy rumor gets started based off of what we just read. That's not the situation. At this point, defendant has only provided notice that he was out driving in the early morning hours of November 13th, 2022, throughout the area of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, to partially corroborate his alibi using CSLI data from defendant's cell phone. Literally what we've heard from day one. However, the alleged offense occurred between approximately 4:07 a.m. and 4:20 a.m. At most, Mr. Ray can opine as to where defendant's cell phone was up until 2:54 a.m. when it was apparently turned off and approximately 4:48 a.m. when it began reporting to a network. Okay, so you see how he just said when it was apparently turned off, meaning he's still going off of what the arrest order stated. That was literally based off of knowledge and experience being assumed by the writers of said order. They're not yet telling us what actually happened. And the forensic download would say that. The timing advance records, according to Cy Ray, would say why the phone was not reporting. If it was actually off network from a lost signal, no service, or actually turned off, put on airplane mode. Like it says that, it gives you that information. So they're still not actually claiming it was turned off. He's saying apparently turned off. So which one was it? Because by now you guys should know. Defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules, and it has a footnote number 16. This does not preclude defendant from presenting Mr. Ray's testimony at trial to rebut any contention by the state that defendant's vehicle was seen on surveillance camera driving to Moscow around the same time Mr. Ray contends he was south of Pullman. However, defendant may not refer to it as an alibi or partial alibi prior to closing. At that time, defendant is instructed to address the issue outside the presence of the jury for guidance on what language related to alibi of any sort may be used. So basically, because nothing that's being actually stated by anybody has anything to do with the actual time frame of the crime itself, according to the state, then it's not considered a technical alibi because it's talking about before and after. Damn, like I can't disagree with that because that's not wrong. That's not wrong. That's not wrong. That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial, and it cites State v. Juarez from 2021. Whether to exclude late disclosed alibi evidence requires weighing prejudice to the state against the defendant's right to a fair trial and considering whether less severe remedies are sufficient. There are still 4 months until trial begins. If defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if defendant does disclose alibi evidence. However, at this point, defendant has not provided an alibi, partial or otherwise. So because right now, whatever is actually in here is not being considered a part of the time of the crime, therefore not technically considered an alibi because of the timings being alibied. They can't technically approve the state's motion because you can't really tell somebody you can't defend yourself. Like if proof comes out, if there is actually a person that's been not spoken about because they thought they could get around it by having location data, and all of a sudden this person comes forward and that's the proof, just because it's past some sort of deadline, they can't deny that evidence coming forward if it is factual, which makes sense for both sides to be able to do such things if there is factual basis behind it, in my opinion. Now, here we go, the Moscow traffic stop. Now, again, in that CW episode that came out, they kept talking about the October one in Pullman as like it was this one, talking about how that's how they had his phone number, his identity, video of his car, all these things. Like multiple people were speaking about it in the wrong way. It was very, very, very strange. This is also a traffic stop that I've tried to FOIA and have been told multiple times that it's still under seal. Now, I tried more than once, and the last time was because there was a document that was actually released by the state, and I sent it over to the administration office that works all the FOIA requests, and I said, they're claiming it's a public document, so does that mean that it's actually public? Do I need to file another FOIA? And they had me file another one while she went to get information, and she spoke with the prosecuting office, and even though it was stated that way in the document from the state, it wasn't public, so my FOIA was denied yet again. And again, this is only supposed to be being submitted for identification purposes, which again, I find redundant because they have his DMV records with his registration and his state license and all the things. Plus, they have information from Pullman PD and WSU. They have like all of these other identifying things for him. They don't need this, especially since they're not using it for premeditation, intent, motivation, opportunity, planning. They're not using it for any of those things that are actual verbiage reasons in the rule itself. Identification only. It seems redundantly stupid. It's not needed. Unnecessary. Waste of time. The state moves under IRE 404B for the admission of defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued a citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's OBV footage of the traffic stop, as well as the citation, arguing it is relevant to proving defendant's identity, vehicle, ownership and control, address, and phone number, which again, they have by all these other ways. Literally all these other ways. Now, it has a 17th footnote, and it states, the judge previously presiding over this case analyzed the admissibility of the OBV footage under IRE 404B in the context of the grand jury proceeding and found it admissible. Specifically, the judge found it relevant to identity and was not otherwise barred by IRE 403. And then it says to see the sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct from back on December 15th of 2023. And again, identity only. Again, things they don't need because they have his Washington State DMV records. They don't need this. Defendant objects, pointing to Idaho Supreme Court case law citing that evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. And then it cites State versus Porter from 1997. Confusingly, defendant argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to identity. He also argues it is unfairly prejudicial and may confuse the issues. It's useless. It's redundant. It's a waste of time. It's not necessary. Evidence of other crimes, wrongs, or acts may not be admitted pursuant to IRE 404B when its probative value is entirely dependent upon its tendency to demonstrate the defendant's propensity to engage in such behavior. And then it cites State versus Salinas from 2018. Such evidence may, however, be admissible for other purposes, including to prove identity. IRE 404B2, when we went over all of those 404s in a different video. To determine the admissibility of evidence under Rule 404B, the court must find the evidence is sufficiently established as fact. And now we have an 18th footnote, but let's finish the full sentence. I don't know why he puts them in the middle of his sentences like this. The court must find the evidence is sufficiently established as fact and relevant as a matter of law to a material and disputed issue other than the character or criminal propensity. It must then conduct a Rule 403 analysis. Now the 18th footnote states, there is no dispute that the evidence is sufficiently established as fact, thus the court need not make a specific articulation on the matter. And then it cites Cook versus State from 2010. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crimes. Why? And how? Come on now. Indeed, the citation and OBV footage, up to the point that defendant provides his phone number, serve to identify defendant by name, physical appearance, phone number, and address. Now we have a 19th footnote. Just prior to defendant providing his phone number, he asked the officer why he needed it. This is after defendant provides his phone number. He and the officer discuss ancillary matters that in no way bear to defendant's identity. Thus, this portion of the OBV shall be redacted. So they're only going to show portions where he says his name, his address, his phone number, and they talk about his car. Everything else about how he asked how the officer feels about people that lie to him about wearing seatbelts and how he says that he doesn't feel like seatbelts are very safe in the first place. All of those things are going to be redacted from the video. Is that what they're saying? And the whole thing about the phone number, now I've asked other people in the Washington and Idaho areas, and it's a mixed bag just in the actual location being spoken about. And there were people in the comments saying it's normal for them, and then there were people saying it's not normal. So I guess it just all depends on the protocols in place for the police department that pull people over, because even in the same state, we're getting yes and no answers. The evidence also establishes defendant as the registered owner and driver of a vehicle, the make and model of which was thought to be used by the killer. Further, the evidence places defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. That's not what the state said. Has the state in any way ever said that it was used for any other purpose besides identity? No. So once again, this is the court leading the state in their case in his own order, because they've never once said that. There's even a document where they came out and said, this is in no way being admitted to prove anything other than identity, phone number, address, car, blah, blah, blah. This is the judge putting this shit in here. Wow. Okay. Wow. All of these factors played a role in the investigation of the crime. And then we have a footnote number 20. I am shooketh by this man right now. Wow. Case law supports the use of identity evidence in this regard. In the recent case of State versus Gordon, Idaho Court of Appeals held that a prior interaction between the defendant and law enforcement, during which the officers identified the defendant with his driver's license and verified his address, was relevant to affirmatively establish his identity for the subsequently charged crime. Likewise, in State versus Algier, I guess that's how you say that, the Court of Appeals held that evidence that witnesses spotted defendant in a car known to have been used while fleeing from the scene of a robbery was relevant and admissible as being probative of defendant's identity as one of the robbers. Okay, but in nothing that the state has submitted have they stated that they plan on using it for this. Literally ever. For him to come in here and state, further, the evidence places defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant on planning the charged crime. What other evidence regarding August 21st of 2022 does the state have? Because this would mean, for him to make this statement would mean that the state has been lying in court and in public viewed documentation filed with the court, and he has seen something that proves that the state has been lying about their intention of actually submitting the traffic stop. Because that's what this sounds like. So either he is leading the state and giving out information he's not supposed to be and proving the state's lying to us, or he's full of crap. While defendant cites to case law discussing identity under IRE 404B as requiring strong similarities between the bad act and the charged crime, this is in the context of establishing identity through a signature quality or modus operandi. And then it makes another citation and says, discussing how evidence of a modus operandi can prove the identity of the defendant as the perpetrator of the crime charge. And there is a 21st footnote that states, noting the demanding standard required to establish identity through modus operandi evidence, Wright and Miller advises that judges to distinguish between the modus operandi exception for proving identity under IRE 404B and other methods of proving identity, so they don't impose the strict standards of proof of the modus operandi exception on other methods of proving identity. The state, however, is not seeking to introduce the prior traffic stop to establish a modus operandi. Therefore, defendant's case law and argument is not well placed. Upon weighing the IRE 403 factors, the only portion of the OBV footage the court finds troubling is when the defendant inquires why the officer needs his phone number. This inquiry could be perceived by jurors to be insolent. Given its lack of relevance and potential for prejudice, the inquiry shall be redacted. I mean, but it doesn't, though. Like, a lot of people were saying that it was odd, so that's obviously just based on personal experience. Other than this redaction, there is no basis for further exclusion. Defendant's claims of unfair prejudice and jury confusion lack merit. First, he argues there is no nexus between the traffic stop and the charged crimes, thus the jury may consider it as propensity evidence or otherwise be confused. However, as discussed, a nexus is not required for the purpose advanced by the state. Moreover, unfair prejudice arises only when the evidence has an undue tendency to suggest a decision on an improper basis and appeals to the jurors' sympathies, arouses their sense of horror, provokes their instinct to punish, or otherwise causes a jury to base its decision on something other than the established propositions in this case. And then it cites States versus Russo from 2014. A traffic stop, particularly one as minor as this, is not the type of evidence that will compel a jury to conclude defendant is guilty of murder because he violated traffic laws. Further, the court will provide a limiting instruction. Defendant also contends it is unfairly prejudicial because the OBV footage provides a clear shot of defendant's vehicle, which may lead the jury to believe it is the suspect vehicle captured on surveillance video at and near the crime scene on November 13th of 2022. However, this is precisely what makes the evidence probative. It links defendant to the crime scene, but it doesn't. You can't even tell what kind of car that is in that video. Let's quit freaking playing. While this may be damaging to his defense, it is not unfairly prejudicial when balanced against its strong evidence. And then we have the 22nd footnote. Defendant also noted at the hearing that the traffic stop occurred on the same day that Agent Balance determined through CSLI analysis that defendant's cell phone was using resources consistent with being in the area of 1122. No shit. No shit. It uses the exact same tower. Those towers cover miles and miles, okay? Literally, he can be in his own apartment in Pullman, not even move, and still bounce off towers depending on traffic up in the air with things that we can't even see that are running through us constantly trying to fight for where they need to go. That's dumb. Of course, if he's at the area where he got pulled over, which is off of like the main highway where the big shopping center is, that's only like 6 minutes. 6 minutes or so away from King Road. Of course it utilized the exact same cell tower. That's not evidence, that's common frickin' sense. Thus, the motion is granted with the noted redaction. So they are going to go ahead and submit this stupid traffic stop, and the only part they're going to get rid of is the part about the phone number. I mean, again, lots of people thought that it was odd. That's weird. Okay, so that's it for the state's motions that Judge Hippler went ahead and put his ruling on in this 17-page document. Now, again, there was a mixture of defense and state motions in this one, and it was a two-parter. Part one, if you missed the defense motion rulings, is going to be down in the description box. The next one that will be coming out is the order regarding the make and model of the suspect vehicle, and we are going to go in order until we're done talking about all of them. But for now, let me know how you guys are feeling about all of this so far down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.